Good morning, ladies and gentlemen.
We welcome you to the 12th Surana Surana International Technology Law Moot Court Competition 2013, jointly organized by Symbiosis Law School Pune and Surana International Attorneys Chennai.
Without further ado, now we commence with the final rounds of this moot.
With due permission of the honorable bench, the counsel on behalf of the applicants would like to begin the proceedings of the court. Much obliged, madam. With due permission of the honorable bench, the counsel on behalf of the applicants would like to proceed with the statement of jurisdiction. Much obliged, madam. Madam, in the instance case, the counsel on behalf of applicants have invoked the jurisdiction of the honorable bench under section 374. Clause 2 of the Code of Criminal Procedure 1973, which provides the power to the honorable bench to adjudicate on the instant matter of minors. With due permission of the bench, the counsel would like to briefly summarize the bench within facts. Much obliged, my lords. My lords, the instant case is an appeal filed before the honorable bench against the conviction of a conviction judgment by the learned judge of the sessions judge against the applicants that is Bioreactivity Limited, Bangalore Agriculture Limited, and National Biodiversity Authority, remarks made by the criminal judge of the negligency of the National Biodiversity Authority, my lords. My lords, in the instant case, India is a developing country with the world's second largest population. Also, my lord, it has to be noted and observed by the honorable bench that India is a country which is among one of the 17 mega diversity countries, of the world, my lord, with approximately 13% of the world flora and 7% of the world fauna, my lords. Further, my lords, the country of India has been very much active in passing on and ratifying treaties regarding the protection of the environment and has been a party and signatory to the Convention on Biological Diversity. Subsequently, my lord, it has ratified the said treaty by enacting the Biological Diversity Act of 2002, my lords. My lords, in this case, the applicant number 1, Bioreactivity Limited, is a company incorporated in the industrial laws of the Indus and has 26% shares of Bioreactive Corp, which is a company incorporated in the country of Sardinia, my lords. Further, my lords, the Bioreactive Corp has anticipated G in the instant case, G, that is the PPG, has been patented by the Bioreactive Corp in the instance case, my lord. My lord, in the instance case, there has been an agreement between Bangalore Agricultural University, and Agricultural University is in the jurisdiction of the Indus, country of Indus, in the Indus, and the Bioreactivity Limited for the research and development of the BT eggplant, genetically modified eggplant, my lord. And whereas the respondents have, in the instance case, have alleged that the said agreement was in violation with Section 3 and Section 4 of the Biological Diversity Act, my lord. It is humbly submitted that the case went before the criminal judge who took the cognizance, trial took place, and the applicants were convicted, and hence the applicants approached this court to challenge the judgment of the criminal court, my lords. In the instant case, my lord, there have been 3 primary issues which have been contended by the applicants. Number 1, that the agreement between the applicant number 1, that is Bioreactivity Limited, and Bangalore Agricultural University fall within the ambit of Section 5 of the Biological Diversity Act, and number 2, that the Section 3 of the Biological Diversity Act is ultra-wise of the Constitution of Indus. Lastly, my lord, the third and final submission deals whether the National Biodiversity Authority was negligent and delinquent in carrying out its duty, my lord. The first 2 submissions before the honorable bench shall be dealt by the council, while the last submission dealing with the negligency of the National Biodiversity Authority shall be dealt by the co-council, my lords. If it may please the honorable bench, the council would like to proceed with the first argument, my lord. Much obliged, my lord. My lord, in the first leg of the argument, the council shall contend that the agreement between the applicant number 1, that is Bioreactivity Limited, and the Bangalore Agricultural University, that is applicant number 2, fall within the ambit of Section 5 of the Biological Diversity Act, my lord. If my lords may refer to Section 5 of the Biological Diversity Act, it clearly states that the provisions of Section 3 and Section 4 shall not be applicable to the collaborative research projects which involve the transfer or exchange of biological resources or information relating thereto between institutions, including government-sponsored institutions of India and such institutions in other countries, if such collaborative research projects satisfy the conditions specified in subsection 3, my lord. For in order to establish that the agreement between the applicants falls within the ambit of section 5, the council shall have divided its argument into 3 subparts, establishing first that the agreement is indeed a collaborative research project. Number 2, my lord, that the agreement in the instance case involves the sponsorship of the government. Number 3, my lord, that the agreement has satisfied the requisites under section 5, subsection 3, my lord, the guidance and the approval of the central government. If it may please the honourable bench, the council on behalf of the applicants would like to proceed with the first sub-contention. Much obliged, my lord.
What is the difference between project and agreement?
My lord, an agreement is basically a contract that is being entered into between 2 parties, my lord, whereas the project is undertaken subsequent to the agreement, my lord.
Whether agreement is condition precedent for project?
My lord, in this case, there is a subsequent agreement is subsequent for the project because, my lord, a collaborative research project as should be established subsequently by the council in approval there is a need for an agreement.
Whether we have to address agreement along with project or agreement differently and project differently.
My lord, in the instance case, the both are in association with each other, my lord. That is, an agreement was there, an agreement, a project undertaken subsequent to the agreement, my lord, it will be established to be a collaborative research project, my lord.
That's what my concern is. Collaborative research project is different from an agreement to transfer.
Indeed, my lord. My lord, that is what the council is contending, my lord. That is what the respondents have also alleged that since the
bench wants to know whether the project envisages also, the word is envisages, section 5 also envisages any agreement.
No, my lord, much obliged, my lord. The council contends that it deals with section 5 specifically deals with the project, my lord. And my lord, the council is shall be establishing the same, my lord, that the agreement, not the agreement, but the project, that is a collaborative research project, which is subsequent to the agreement between the applicants, my lord. If my lord is satisfied with the...
No, I am not here to give any entry whether I am satisfied or not. Well, the second one is such institution. How we are going to interpret the word such institutions?
Indeed, much obliged, my lord.
Government-sponsored institutions of India, and such institutions means the other institution also should be government-sponsored institutions. That is the plain reading of the Act says.
My lord,
what is the facts represent?
My lord, the council indeed, my lord, as already pointed out by the honourable bench, that in order to establish a plain exception in section 5(1), it is important to understand the concept of the institution, and the council shall in subsequent part of its arguments which establish the same, my lord.
The bench wants to know is simply a legal proposition. If it is a private institution, the counterpart also should be a private institution, or if it is a government institution, it should be a government institution. So because of the usage of what? Such institutions. Whether the project should be between private or government. It cannot be government and private. What is the legal proposition? A plain reading of section 5(1). Because of the usage of what? Such, including government-sponsored institutions of India and such institutions in other countries, whether the other institutions should be a government-sponsored institutions or not. That is a legal question and procedure.
In the instance case, much obliged, my lord. In the instance case of the said providings, the council states that it submits before the honourable bench that the project involves the institution. It might be both the institution, might be the private institution, but my lord, the private institution is such that it should be sponsored by the respective governments, my lord. And my
what is the person that? Whether the project is sponsored by the company.
My lord, the project should be made, criteria is placed down that the sponsorship should be government, irrespective that whether the funds are received from private institutions or not, that is irrelevant part for the section, my lord.
So that is why I asked you a basic question. Project is divide up, agreement is it? The project could be between 2 countries, but the agreement could be between an individual company, and the transfer agreement could be different.
Indeed, my lord. The project, the agreement can be occurred between countries also. The project can be between the 2 countries also, and between 2 parties also, private parties also, my lord. In the instantaneous case, there are two private parties which are sponsored by the governments, respective governments, my lord. If the honorable bench is convinced by the argument, the council can proceed.
Just read section 5(3)(a).
Indeed, my lord. Another section 5(3)(a) states that for the purposes of section 1, the collaborative research projects conform to the policy guidelines issued by the central government in this behalf.
Has the central government issued any policy guidelines?
My lord, the central government has issued the policy guidelines regarding the collaborative research projects. However, the council should beg to differ on the point that these guidelines shall not be applicable in the instantaneous case, as these guidelines were stipulated by the central government in the year 2006, while the agreement and project was undertaken in the year 2005, my lord. And hence the guidelines shall not be applicable in the instantaneous case.
In that case, we read section 5(2).
Indeed, my lord. All collaborative research projects other than those referred to in subsection 1, which are based on agreements concluded before the commencement of this Act and in force, shall to the extent the provisions of the agreement are inconsistent with the provisions of this Act or any guidance issued under clause A of subsection 3 be void.
So are you going to say this point?
No, my lord, the council would beg to differ on the issue because, my lord, the council emphasizes that on the second line of the section 5 which states all collaborative research projects other than those referred to in subsection 1 and which are based on agreements concluded before the commencement of the Act, my lord. My lord, in the instantaneous case, the Act had already come into force in the year 2003 and the guideline was stipulated in 2006 when the agreement took place in 2005. So, my lord, the agreement in the instantaneous case between the said appellants do not fall in the section ambit of section 5(2), my lord, and shall not be declared void, my lord. It is humbly submitted, my lord.
That's why I asked the question whether an agreement must precede the project. Reading section 5(2) it says, which are based on agreement. So a project must be based on agreement.
Indeed,
That's why
my
I
lord.
asked you.
Indeed, my lord. My lord, the council submits to the same, my lord.
So where is the agreement that precedes the project?
My lord, the agreement is the annexure A, the form annexure part A of the fact sheet, my lord,
Tell me where
based on which the project is there.
which one is it? It is after the project or before the project?
I beg your pardon, my lord.
After the project is commenced or before the project commenced?
My lord, the agreement took place in 2005 and thereafter the project took place, my lord, in the same year, my lord.
So then that agreement, any part of the agreement which is inconsistent with the PDR will be void, isn't it?
No, my lord, the council begs to differ on the issue, emphasizing on section 5(2) that all those agreements, my lord, which are inconsistent either with the guidelines or the provisions of the Act. Before the commencement of the Act, my lord, all the agreements concluded. My lord, in the
When the Act came into force?
Indeed, my lord.
When the Act came into force?
Indeed, my lord.
Tell me the date.
I beg your pardon, my lord. The Act came in 2003, my lord. It was enacted in 2002, and the provisions were enforced in 2003, my lord, and some provisions in 2004, my lord.
So your agreement is in 2005.
Indeed, my lord.
Then it is covered under PDR.
My lord, that is what the council said, and the agreements concluded before the commencement of the Act, my lord.
What is the intention of a legislature? What is the intention of the lawmakers when they give such a provisions? When they give, what is the spirit of the law?
My lord, in the instantaneous case, the section 5, basically, my lord, that the emphasis should be that the industry is developing countries with biological diversity, my lord. However, the developing countries do have resources, do not have the technology to take those resources. The purpose of section 5 is to promote those research projects, my lord, under which a foreign institution which possesses the technology and, my lord, the developing countries, the institutions in the developing countries which have the biological resources would be used to promote biotechnology and the advantages to be served to the farmers, to the agricultural associated people associated with agriculture in this manner. The purpose of the section is such, my lord. In pursuant of the same, my lord, the agreement, that is the technological transfer agreement, as mentioned in the paragraph number 15 of the fact sheet, there exists a technology transfer agreement between the government of Indus and government of Armenia, and an agreement was signed between the Bangalore Agricultural University and the Margaret Junior Limited, the applicants in the instantaneous case in 2005, my lord. And hence it has been contended by the applicants in the instantaneous case that it falls within the ambit of section 5, my lord, since it is a collaborative research project. And, my lord, it satisfied the criterion rate of the 5(3)(a) and B, which shall the council subsequently establish.
The problem is, if the collaborative agreement is between university and university, section 5 will be square B, so the exemption will be applicable. But it is not so. It is between a company, private company, and the university. So going by the wording such other institutions, so it defeats the purpose of section 5.
मतलब like
It goes beyond the legislative, thinking of, if you have to accept your interpretation, it's going beyond the legislative intention.
However, my lord, the council would beg to differ on the point, my lord, that the word such institutions mean that the institution of the country of Indus and a foreign institution, my lord, which are sponsored by the respective governments, and not the similar nature of the institutions, my lord.
Whether the company is government sponsored in this case.
Indeed, my lord, the funds for the entire project as stipulated in paragraph 15 of the fact sheet.
How do you define the word sponsor? Funding alone?
My lord,
Day-to-day activities, control of sponsor means what?
my lord, that is what the council is contending here in this case.
Sponsor has two differences. Company itself is sponsored or project is sponsored. Which one you are thinking?
My lord, the project should be sponsored by the government respective parties in project involved. My lord, in the instantaneous case, the project should be sponsored.
Where money is coming from this project?
Indeed, my lord,
From the fact sheet. From the fact sheet.
Indeed, my lord, paragraph 15 of the fact sheet.
What it says?
It stipulates, my lord. It stipulates in my lord, the last 4th line. He also informed that the project was partially funded by the government funds and partly by the grant of Sardinia National University and also the government of Sardinia, which was based on a high-level technology transfer agreed to by government of Indus and government of Sardinia.
So whether the technology is given to the Sardinia government or to the company?
I beg your pardon, my lord.
The transfer of technology or whatever is the finding is given to the Sardinia country or to the company?
The beneficiary.
Yes.
The beneficiary. Who is the beneficiary?
My lord, in the instantaneous case, as per the agreement, the next day, my lord,
What about the agreement? Who is the actual beneficiary here?
my lord, the
The
Sanglo
Sardinia
Agricultural
country or the company?
My lord, the Sanglo Agricultural University under the project, my lord, which,
Who is the beneficiary? Actual beneficiary?
my lord,
Whether the finding goes to the Sardinian government which partly sponsors the project or it goes to the company for getting a patent.
Commercial benefit.
Yes.
my lord, this project, as it is somebody connected, this project is not for the commercial utilization, because my lord, this is
You don't understand my question?
my
I
lord,
make it very simple. So you are going to transfer the findings. Actually the findings, the transfer of technology or findings going to land in whose lab? Whether it is a government's lab or the company's lab.
my lord, it will go with the government of India or the Sanglo Agricultural University, my lord.
Read section, read paragraph 13 of the facts.
Indeed, my lord.
First line.
In 2008, the Department of Biotechnology gave commercial approval to market a genetically modified eggplant variety of Bio-Jeevanti Limited, my
Now,
lord.
who is the beneficiary?
My lord, Bio-Jeevanti Limited. However, my lord, what the council contains in the instantaneous case, my lord, that it's a purely research project and no commercial exploitation is being sought in the instantaneous case, my lord. And even the commercial approval is being sought is just solely for the purpose, for the marketing purpose, to channelize the product so that the product may be made available to farmers for which the entire product has been developed, my lord.
You are going to give it for free. Why do you want to market the product?
My lord,
Are you contending Bio-Jeevanti is going to give these seeds for free to these farmers to harvest eggplants?
my lord, the facts are entirely silent upon the issue. However, my lord, what the council is just contending in this case, that the purpose of the project, the entire project was mere research and development, and the marketing approval, commercial approvals in accordance with the rules laid down under the rules by the Ministry of Environment and Forest, my lord. And this commercial approval is needed for if any of the genetically modified product is to be released into the market, even for any purpose, be it for free or be it at cost out of the profit. My lord, the entire commercial approval from the department is needed, my lord, in this case, and that is why such approval is sought.
Can we differentiate now the approval for research and approval for commercial purposes? What is the procedure for approvals that are related for research in GMPs and what are the approvals that is required for commercial release of GMPs? And commercial release, at the end of the day, given the fact silent, no company is going to take commercial approval to keep it or give it for free. Commerce means commerce. It is simple common sense that you have to use to say that any person taking commercial approval takes a commercial approval only to exploit it commercially. So if you are going to take this contention, then please tell this bench what is the difference between a research GM and the commercial approval NGO.
Indeed, my lord, the research, definition of research has been stipulated under Section 2, Clause M of the Biological Diversity Act. With due permission, the Council like to read the Act. Much obliged, my lord. My lord, Section 2M stipulates research means study or systematic investigation of any biological resource or technological application that uses biological systems, living organisms, or derivatives thereof to make or modify products or processes for any use, my lord. In the instance, the entire research is being done. The Biology Limited Bangalore Agricultural University both had entered into agreement to incorporate that gene into eggplant to test that, to conduct the field trials, for all of which the approval with the concerned Department of Biotechnology has been taken, my lord. And my lord, commercial approval, commercialization has not been defined anywhere in the Act. However, commercial utilization has been defined under the Act, my lord, which states.
You don't have to read it, you don't have to read it.
Indeed, my lord. Much obliged. My lord, its commercial utilization is defined in the Act. However, my lord, it is humbly submitted that this project, if the honorable bench refer to the annexure, this project entirely is for the research purposes, my lord.
Just one last question.
Indeed, my lord.
You are here because you are convicted.
Indeed, my lord.
Now please tell this bench for what particular act have you been convicted?
My lord, the learned judge of the criminal court have convicted applicants for violation of Section 3 and Section 4 of the Biological Diversity Act.
You have been found guilty of Section 4, 3 alone, I believe.
My lord, the council represents the applicant number 1, that is Biorage Limited, and applicant number 2, Sangal Agriculture Institute, both of them, my lord. And Biorage.
Appellant 1,
My lord, applicant number 1 was convicted only under Section 3 of the Act, and
can you address on that issue? How you are convicted under Section 3
my lord,
as an appellant 1?
my lord, what the council is simply contending in this case is that the Section 3 of the Biological Diversity Act stipulates the prior approval of the authority was so to be sought.
In general,
I beg your pardon.
in agreeing that if you are not agreeing with the argument that you are not getting exemption under fine, so what will be your answer to her? Because you are an appellant.
My lord, then the council contends that the Section 3 would not be applicable in this case.
That's what I am saying here.
Address that issue.
Yes, address that.
Much obliged, my lord. My lord, the Section 3 of the Biological Diversity Act stipulates, my lord, that no person referred to in Section 2 shall, without the prior approval of the NPA, shall take any research, my lord. Further, my lord, council has challenged in its second submission the constitutional validity of the Section 3 itself and shall prove that there is no reasonable nexus of the Section 3C2 enshrined into the Act and the object sought by the legislation, my lord. And since the Section 3 would be ultra-biased in the instantaneous case, my lord, and the council shall establish Section 3 would not be applicable on the applicants in the instantaneous case, my lord.
Constitutional validity is presumed in favor of validity until you disprove.
Indeed, my lord, council shall establish that.
At this stage, you cannot take that argument. If you want to address specifically on constitutionality,
Much obliged, my lord. My lord, to proceed with the constitutional validity point, my lord, the council challenged in the instance the validity of the Section 3 of the Biological Diversity Act, violating the Article 14 of the Constitution of India, my lord. My lord, the Article 14 provides equality before law and equal protection before law, my lord. There are two criteria laid down by the Honorable Court in various judgments. The council contends in the instance case that there is no reasonable nexus between what is sought under Section 3C2 and the purpose of the legislation, my lord. My lord, the purpose of the legislation can be referred or can be concluded from the preamble of the legislation, which states the primary.
Council, are you aware of Article 31C?
My lord.
Please read Article 31C of Indian Constitution. Please read. You are not aware of Article 31C and challenging the constitutional validity of PD Act before us.
My lord, the council is not in possession of the.
Yeah. Pass it over. You are arguing before us without a constitution. Pathetic.
I beg your pardon, my lord.
Very pathetic. Read 31C. Saving of certain acts.
Indeed, my lord. Notwithstanding anything contained in Article 13, no law giving effect
to
the policy of the state.
the policy of the state shall be questioned in any court of law if it gives effect to any directive principles. Am I right? Part 4. So with reference to 48A and 51, this Act gives effect to directive principles. This cannot be questioned as violative of Article 14 and 19 in any court of law.
However, my lord, the council contends that there is no reasonable nexus between.
Forget about it, you cannot even question that. You are prevented from questioning the validity of the Act by virtue of Article 31C. Then where I can go into the merits of the case. Read it aloud again. 31C, read. Again.
Indeed, my lord. Notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abuses any of the rights conferred by Article 14 or Article 19, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground.
Question in any court of law?
That it does not give effect to such policy.
Yes. So you cannot question the validity of BD Act under Article 14 and 19 because it tries to give effect to two directives, 48A and 51. That is CBD. It is trying to give effect to CBD and also 48A. It is duty to protect the biodiversity. So you cannot question the constitutional validity of the BD Act because it is giving effect to directive principles.
My lord, however, the purpose of the convention, my lord, is to, for the purpose of the sole purpose, if the honorable bench may permit the
No. There is a constitutional provision, 31C, you cannot raise any issue relating to constitutional validity of any act which is giving effect to all or any of the directive principles found in Part 4 of the Constitution. Very simple. So 48A is a directive principle. So under that only BD Act is being enacted, and also 51A giving effect to international agreements, international principles, customary law. So under these two principles only BD Act has been, in order to, the objective clearly says, in order to fulfill these two directives, the Act is being created, enacted. So you have no constitutional authority to challenge the constitutional validity of this BD Act.
My lord, the council would like to go before the will of the honorable bench and shall humbly submit like to seek permission to sum up the arguments. Much obliged, my lords. Much obliged, my lords. My lords, in the instantaneous case, it has been humbly submitted before the honorable bench that the applicants, the project included in the agreement between the applicants fall within the ambit of the Section 5 of the Biological Diversity Act, and hence the exemption is being sought in Section 5, rendering the Section 3 and Section 4 inapplicable in the instantaneous case. Hence it submitted that the conviction of the applicant number 1 and applicant number 2 be set aside. If it may please the honorable the council would like to invite two council to the photograph of minutes. Much obliged.
Did you permission the honorable bench the council like to preside? Due permission, the council would like to start with the third argument. Lordship, in the third issue, the NBA was prosecuted. The third appeal is regarding the conviction of the regarding the prosecution of NBA, and it is in this under this appeal, the NBA seeks to expugn those remarks made by the learned judge. Lordship, the National Biodiversity Authority was prosecuted before the criminal code under Section 304A of the Indus Penal Code for causing death by negligence, Lordships. But Lordships, it was not convicted in that case due to lack of evidence, but the learned judge criticized the role of NBA for giving such approvals to Lordships. Lordships, the council would, before moving on to the arguments, the council would first lay down what are the essentials of Section 304A under the Indus Penal Code, Lordships. Lordships, the first essential being that there must be death of the person in question. That is, there a person of age.
You are not convicted under 304A.
Yes.
So there is no question of you addressing that issue because you are not convicted at all.
Indeed, Lordships.
So
But the
before us.
Lordships, the authority is here to expugn those remarks because the authority here would, the council would here prove
beyond reasonable doubt that the authority cannot be liable, made liable for cannot be negligent for those deaths, because there are two things, lordships. The first thing is under section 304A that there should be a negligence, and second thing, there should be deaths because of that negligence. Now
You are not convicted.
indeed, your lordships. Now, why we are not convicted? Because there is the thing which is missing here is the evidence that the deaths have been caused because of the consumption of BTX plant.
Yeah.
But what the
Para 18.
indeed, lordships.
Yes. And also sought an action against officers of NBA for dereliction of duty and negligence causing death. So the second part is the court has not taken cognizance and they are acquitted you. 304 is not in the picture also. Please refer to last paragraph also, paragraph 24. Paragraph 24.
Lordships, paragraph 24
The
is
court strongly criticized the role of NBA. That's all.
lordships.
So dereliction of duty. That's it. That's what my brother judge wants to point out.
Indeed,
Why are you
lordships.
considering that you have been convicted, or was there some remarks with reference to 348?
Indeed, lordships.
There is a
Because
presumption.
lordships, the criminal code strongly criticized the role of MBA, but stopped short of convicting the officer, as death could not be established due to the conviction of BTX plant. Now, the lordships, it is clear in the
Also, since there is no evidence of corruption.
lordships, in the lordships, please refer the final clarifications for the fact sheet, paragraph number 13, in which the Tamil Nadu has charged NBA under section 304A, NBA as a regulator to perform its duty to grant approvals. Now, what the criminal code has, the judge,
You have been acquitted of 304.
indeed, your lordships.
The only thing the criminal code held is that your officers did not perform their duty in a manner they were supposed to perform their duties.
And your lordships.
So you are asking us to expunge those remarks. Can you present any argument to say that your officers perform their duties in a manner that the statute has intended?
Indeed, lordships. Lordships, section 18 of the Act, read with Rule 12 of the Biological Diversity Rules, it says that the duty of the National Biological Authority is to lay down the guidelines, and it has a duty to assist the government and to ensure that the provisions of this Act are being implemented. Lordships. Lordships, will please refer the Moot proposition. Lordships, as soon as the complaints were being made by the Future Farmers Foundation and the 5 other farmers, lordships, an inquiry was being held. By the National Biodiversity Authority. Lordships, please refer paragraph 15 for the same of the fact sheets. Lordships, the inquiry was being laid down, and after the inquiry, and it was found that there is some content in the complaint that the NBA prosecuted the appeal number 1 and appeal number 2 before the Government Judge of the Criminal Code. Lordships,
Show me a provision in the Biodiversity Act which gives you a right to inquire. Once you get the complaint, what are you supposed to do? I would have rather seen you here as a respondent than as an applicant. Why didn't you go to the court instead of asking this trust and the 5 farmers to do?
Lordships,
what were you doing? That exactly is what the magistrate has charged you with.
Indeed,
Not
lordships,
performance of duty.
Indeed,
You were
lordships.
supposed to take action, you did not take action, you're sleeping over it, and you're saying you are inquiring. Please show me a provision under the Biodiversity Act which gives you the power to inquire or investigate.
Lordships, please.
Read section 54.
Indeed, lordships.
You have not referred to 54 at all. That is how your research is all about. No suit, prosecution, or other legal proceedings shall lie against the central government or the state government or any officer of the central government or the state government or any member, officer, employer of the National Biodiversity Authority. You will not refer this section at all?
Lordships, the council here contains a different contention. Lordships, first
Use of
addressing
blanket protection for the NBA.
Lordships, it is a blanket for MBA, but the contention.
For the law enforcement.
Lordships, the council has a different argument which would prove that the NBA cannot be negligent Ultimately, for
When you have a statutory protection, why are you looking for some other argument?
Lordships, because the
In
enemy.
the absence of statutory protection, you can go for viable alternate arguments. But you have a statutory protection under R54.
Lordship, that is a protection under section 54, but Lordships, the council here contends
Have
that.
you referred to 654 at all?
Indeed, Lordships.
Have you raised it in the lower court?
No, Your Lordships.
See, my brother, that is trying to
Help you.
help you out, but you do not want to.
Lordships, the council understands that, but the council has a different contention. If the Lordships may please listen to that contention, the council will prove beyond
Then
this.
you need to convince us on that argument.
Indeed, Lordships, the council would contend that, Lordships. Lordships, the council has three-pronged argument to prove. Firstly, simplifying the facts, Lordships, the criminal code has, as it was a regulator of the for giving the approvals. Now, what it has, the criminal code has made the remarks that when the approvals were given, the authority was negligent in its acts. Now, because these approvals were given and because due to the alleged consumption of that BT plant for which the approval was given, the threats are caused. Now, because there was no evidence for the consumption, so they were not convicted, but the remarks were made because.
The remarks were meant to convey that there is a lack of application of mind on the part of the officer.
Indeed, Lordships. Now the council here contends that the council has three-pronged arguments to prove it. The first one being that there is a procedure through which the applications regarding the projects on genetically modified crops are approved or rejected. Second pronged argument being that the role of FDA in that process is just limited to ensure that the biological resources are obtained in a proper manner as provided under the provisions of this Act, and to ensure that the benefit sharing is made if required.
You have to prove that the application of mind was actually done in this context.
The Lordships, the thing is that if any death is caused by the consumption of BT eggplant, what the issue arises is, was the BT eggplant that dangerous, it was not biosafe? Now, then the question comes that if it was not biosafe,
You are exonerated from the deaths. There is no questions whether you are responsible for the deaths. The only observation of the magistrate was that your officers did not perform the duty. What specifically you have to address is the Future Farmer Foundation sends you a notice.
indeed, Lordships,
30 days time is given to you.
indeed, Lordships,
You are saying your obligation was to see whether the procedure is followed.
indeed, Lordships.
It would take you 1 minute to find out that BioRef Jyoti has not made a single application to you.
The Lordships,
What stopped you from going to the magistrate? What stopped you? Why couldn't you go to the magistrate instead of the farmers and the Future Farmers Foundation?
Lordships, the authority has went to the magistrate and has filed a complaint. It is provided in the fact sheet on paragraph number 18 that NEA also filed complaints against the BioRef Jyoti Limited and Bangalore Agricultural University.
That exactly is the point. At what point did you go to file complaint? It is only after respondents reached the criminal court.
Lordships, as soon as the complaint was made, the inquiry was, the authority inquired with the accused that what is their defense, and then on listening to that, when the authority found content, they filed the complaint.
Show me one accused who will come to you and say, I am guilty.
Lordships, they have to be given the chance to provide their documents and their approvals, Lordships.
In short, you have not satisfied this bench that once a complaint was made, you are sitting on this complaint for 30 days without doing, because without the 30 days passing, they would not have approached the magistrate's court. So it is very clear from the facts that they have approached the magistrate's court only after 30 days. 30 days your officers did nothing but inquire when all you had to do was look into your office.
They have filed a complaint before the criminal court, and they have prosecuted.
Since you are not taking statutory protection and arguing on other areas,
Lordships,
granting of approval is an executive action or it is a legislative action? Granting of approval.
it is an executive.
Yes, wonderful, wonderful. Then if it is an executive action, then bias will come in. Three kinds of bias: pecuniary bias, personal bias, etc., etc.
Indeed.
So, referring to joint reading of para 12 and 16, can you tell if there is a bias or not? A joint reading of para 12 and 16, whether any bias is there in granting approval.
Your Lordships,
whether it is done in good faith or not in furtherance to section 54.
Your Lordships, that the two paragraphs, the paragraph number 16,
12.
point,
12. Who gave the approval? Who was the
The
who
report was
submitted the
submitted.
report? Who
Indeed.
submitted the report?
Nimla Kanan, Miss Nimla Kanan, Your Lordships.
16 in 2000. What is which year is that? 2006.
2006.
Who gave the approval?
Miss Nimla Kanan, Your Lordships.
So there is a bias.
No, the council back to
Administrative law bias, administrative bias, personal bias.
Your
So
Lordships,
that is why they have questioned it. That is why the lower court has passed the strictures.
Lordships, the council back to
Otherwise, we will come with the strong strictures. Sometimes in appeal, the punishment will be enhanced.
Lordship, the council
The
understands
lower court
concern
is
of
not a
the
court of record. The lower court is not a court of record. It cannot punish it for its own content. So why are you standing before me? Like my brother judge asked me, you should have been in the respondent side.
The Lordship, the council understands the concern of the Lordship for the conservation of the resources, but the Lordships in the instant case,
You admitted that it is an executive decision.
it isn't your
But
Lordship.
then there is a personal bias.
Lordship, the
That
council
is
back
why
to
should we remove the strictures?
Lordship, the council
Give me
contends here.
one reason, council be fair. Give us one reason why should we remove the strictures from the lower
Lordship,
court. Lower court judgment is not a court of record. It cannot punish it for its own content.
Indeed.
And also it is a personal bias is there. Executive decision.
Lordship, the personal bias is not there. The council backs to differ on the point of personal bias because now here what the issue is related, or what we are restricted in this issue, the particular
It
appeal.
clearly says NBA looked into the files of the approval and found that
For
the
the
permission was granted to transfer research results, but the company had written to the chairperson Imlak and who had approved the changes to standard classes that prohibited transfer of biological materials without seeking.
Any legal advice, Your Lordship,
That is why
but
personal
those-
bias is there.
Your Lordship, that approval was given for the transfer of research results of BT Cotton. Your Lordship, please refer to line number 4 of this report.
2 minutes back, you stated that in fact the bench is getting an thought that probably you are colluding with the company and the university. Because
No,
you
you're
are
not.
admitting that there is nothing. You are admitting as a government, you are admitting that you do not find a violation, and on the other hand you file an application. So are you going to tell this bench that you are colluded with the company and the university?
No, Your Lordship, the appeal of the National Judicial Authority is limited to expunge the remarks made by the learned judge of the criminal court, and Lordships addressing the question of the Lordships, please refer line 4. The approvals given by Nirmala Kanan, the file of approval was regarding BT Cotton, and what we are restricted in this appeal, the issue is regarding the approval granted to BT Eggplant. Now, the approvals, no approvals were granted by NBA for BT Eggplant is clear in the clarifications, Your Lordship.
It's a policy decision. It is a policy decision.
It is a policy
Approving of genetically modified organisms, marketing them. It is not pertaining to a particular, whether cotton or eggplant. It is a policy decision approved in MBA. That is why we are seeking your clarification whether it is executive decision based on the personal bias.
Your Lordships, the council here contends that this appeal has been made against the remarks made by a learned judge, where the prosecution was related to our prosecution was under section 304A, and that was causing death by negligence. Now, when we have not been convicted there, they have made a remark that your officers have been negligent while granting approvals for the BT Eggplant due to which the deaths might have caused. Now, the council here contends that the NBA has no duty under the Act to ensure that the project, the resources which are being taken in the project are biosafe or not. It is the duty of the GEAC, the Genetic Engineering Approval Committee, which is set up under the rules of the Environment Protection Act. That committee has the duty to ensure that the GM crop research is biosafe or not. Any negligence on approving that thing, the negligence would be of the GEAC, not of the NBA. Lordship, the NBA is restricted to ensure that the benefit sharing has been done and the approvals have been taken in accordance with the provisions of the Act, Lordships. That is why the council here contends that in any manner the learned judge would not have made that remark in that
So-
case.
Going, if the bench has to accept your argument,
Yes, Your Lordship.
you are delimiting your scope, your powers. That means you have absolutely no say in biosafety issues.
Indeed,
Biodiversity Authority,
Yes.
NB has absolutely no say,
No say.
nothing itself, but it is supposed to be the comprehensive act covering all aspects of biotechnology, biodiversity conservation.
It's regarding the approvals we
So
taken
your
because-
argument will be self-defeating of the act. Please, you are walking on a tightrope.
Lordship,
For petty reasons, you are sacrificing at the altar of God. You are sacrificing a great act.
Lordship, please
Mindful of your argument. I'm just asking you. Your argument,
Indeed,
your
Lordship.
argument is it is very sweet into my ears. But ultimately,
Lordship.
that will encroach upon the powers of the NBA, and you are representing NBA.
Much obliged, Lordship. The council would provide. May I please refer to laws to be given by the council. Lordship, one would be the rules of manufacture, use, import, export, and storage of the harmful microorganisms. The rules under the Environment Protection Act, under which a GEAC is formed, in which it is clearly laid down that it is a duty of the GEAC.
You are not understanding what you are trying to tell. You have been exonerated from causing deaths.
Yes.
What you have been asked is, why didn't you act when a complaint came before you? Why didn't you act? How many times have a magistrate looked into the action of the police even when the magistrate gives an acquittal? Is the police every time going in a field asking the courts to expunge remarks?
Lordships,
That exactly is what you have done. You have got a complaint, you did not act upon it, and now you are coming before us, not wanting to take any statutory defense that you would get, and you are trying to convince us that you did not cause the death, which is exactly the finding of the lower court.
the Lordships, the council humbly contends that the council has already contended that the criminal complaint was made before the judge, and all those days which were being used by the authority were taken in good faith under Section 54 of the Biological Diversity Act, and just to inquire, just to make an inquiry before proceeding to the court, that Your Lordships, because when a complaint is made, you have to ensure, Your Lordships, Lordship, please refer to Section 61, cognizance of offences. So in that it is given that central government or some authorized officers or the benefit claimers could come and they can make a complaint. Not just when these complaints come, the authority has to ensure, but first, that whether these persons who have come before making the complaint are the benefit claimers, then they have to ensure that the complaint made has a content or not, and finding
That has been cleared, I think. That class will. Notice have been given, everything is in proper.
Notice have been given, Lordship,
If I remember rightly, the clarification is given clearly that the notice has been given and also NBA is authorized to take necessary action.
Indeed, Lordship, the NBA is authorized to take necessary action. The notice has been given by the Future Farmers Foundation. But after the notice has been given, it is the duty of the future. It is
So
on behalf of the.
this bench sits in dual capacity.
Lordship,
No
please
problem, no
go.
problem. There you go.
Much obliged, Lordship.
This court sits in dual capacity, am I right?
Indeed,
As an appellate authority
indeed,
and also under 226.
indeed,
Is that clear?
indeed.
You agree? So now, that's what your co-counsel argued. Constitutional validity of the act under 226 of the Constitution, am I right?
Indeed. Under 226 he can get constitutional validity.
When we are sitting under 226, can we issue a writ of mandamus to NBA?
Lordships,
It's a statutory duty, isn't it?
Lordships, the writ is just the
Now
writ
you
is just
are
limited.
going by your argument.
Lordship,
This
the
bench is tempted to ask this question. Can we give a writ of mandamus to go into this matter?
council will address that.
We will expunge the tinctures and give a mandamus. What is your position?
Mandamus regarding what, Lordships?
Performing your statutory duty.
Lordships,
What
statutory
else?
duties have been
Mandamus is
performed.
body for
Lordships,
performing statutory duty.
Much
What
obliged.
else?
Much obliged, Lordships, but the statutory duties the council has already conducted. It has been followed, it has been performed all throughout, and what all are the duties under the Act, it has been ensured. Now, what has been ensured is that the benefit claim has been taken. These all are the duties of the NDA, not the biosafety, Lordships. Again, Lordships, the Council contained under 226 is just limited to the constitutionality of Section 3, Lordships.
So we have only limited capacity. Fine.
Lordships, that would be an educational question, Lordships, otherwise.
So selective amnesia should be there with us.
Lordships, that would be a...
I think you evaded the issue that bench had with regard to your framing GAC
Yes.
with regard to decision making on biosafety. That compromises the authority of NPA.
Indeed, Lordships.
If you are taken seriously, you are actually compromising the authority of NPA.
Lordships, the Council is not compromising. The Council contains that the authority has been established under the Act. Now, the powers to the authority are being given under the Act. The powers are given just to ensure that Section 3, 4, 6 are followed. Under Section 21, benefit sharing has been made. All these things are properly done. Now, the biosafety issue has to be dealt by the GAC. The Council will provide the 6th meeting, the minutes of the 6th meeting of the of the National Biosafety Authority. Lordships, on page number 3, the comments made by D.D. Verma, the member secretary in the minutes for the meeting, the highlighted part of Lordships. Lordships, it is clearly written there that the mandate of giving approval regarding GM crops is not of the NDA, it is completely of the GAC, because the crops, the genetic organisms included are maybe harmful, because GM crops have to be biosafe for the human consumption if they are to be subsequently released, because after the research they have to go to the field trials. Also, this is the duty of GAC to ensure that any application regarding GM crops, if it comes, it goes to the GAC. It is the mandate of the GAC to ensure that the crops are biosafe.
And so, are you taking genetically modified the crops outside the purview of the Biodiversity Act?
Lordships, the mandate to approve first that the application has to be approved for a genetically modified crop is to be given by GAC. It's a procedure, Lordships, because it involves these harmful microorganisms. It may involve harmful microorganisms. Now, Lordships, when it goes to the GAC, then it comes to the NDA.
The authority of GAC is very clear. Does
Indeed.
not actually take the responsibility of the Biodiversity Authority.
Lordships, the Biodiversity Authority has no responsibility regarding the biosafety. The provisions can be.
Council, you have not read the Act.
Lordships, the Council has read the Act.
We have read that. Please refer to Section 36, 4(2). The role of the central government shall undertake measures to regulate, manage, or control the risk associated with the use and release of living modified organisms resulting from biotechnology likely to have adverse impact on the conservation, sustainable use, biological diversity and human health.
Indeed,
It
Lordships.
is the role of the central government recognized under the PD Act. So you cannot evade NBA's.
Indeed, Lordships, and for that, the central government, this has to be ensured by the central government. When the approval of the central government has to be taken,
Assume that central government has given it power.
Lordships,
By the rules it has been given to you.
indeed,
Have you
Lordships,
read the rules? The
indeed,
central government has, by the rules, framing the rules, it has given powers to the NBA for these purposes also. Don't think that it is not the duty of the NBA to look into the biosafety. Because another reason is, Cartagena Protocol 2000 is also under CBD. This is also under CBD. Therefore, biosafety comes squarely under BD Act. You cannot evade your responsibility simply pushing it back to the court of the GAC, and you cannot say you are not responsible for biosafety.
Lordships,
Or in this cabinet, convince this when the central government is different from NPA.
Lordships, the Council here contains that under Section 8 the authority is being established, and it is a statutory corporation. Lordships, it's not central government is the cabinet. Now, Lordships, if the central government has to ensure liabilities for the central government, not the national biodiversity
What do you mean by statutory corporation? Funding is coming from where? For biodiversity? From which fund? Funding is coming from which fund?
Biodiversity fund.
Consolidated fund.
Consolidated fund.
So directly it is a central government agency. You have not read the act fully.
The
It is from the
council
consolidated National Biodiversity Authority is constituted under consolidated fund.
much obliged to Lordships, the council apologizes for that part. The Lordships, the council here would now would contend that because again the powers, the duties which the authorities bound by are under these provisions of this act, Lordships. Now,
So the argument is very, very technical. That is what is our concern. Thank you very much. I think time is up. Yes. Go to your prayer.
much obliged to Lordships.
Much really.
Therefore, in the light of the arguments advanced, facts cited, and authorities cited facts mentioned, the Honorable Court will be pleased to adjudicate that the appellant number 1 and appellant number 2 fall within the ambit of section 5 of the Act, and hence they need not require to take approval under section 3 and 4 of the Act, hence their convention will be set aside. Also, your Lordships, that the remarks made by the learned judge against the NBA must be excluded.
Thank you.
Much obliged, Your Lordships.
Now Ms. Sam, can you take the next class?
If it seizes the court, may the counsel stand in the case on behalf of respondent. Much obliged, Your Lordship. If the court is well versed with the facts of the case, counsel would like to proceed with the issues raised.
There is no presumption in law that we should know the facts.
Then counsel will clear the bench with the facts of the case, Your Lordship. Proceeding with the facts of the case, Your Lordship. This is an appeal case, Your Lordship, filed by the appellant, that is Biologist Jeevanti Limited, Bangalore Agricultural University and National Biodiversity Authority regarding the decision given by the criminal court magistrate of the country of Bangalore for convicting Biologist Jeevanti under section 3 of the Biodiversity Act 2002, Bangalore Agricultural University under section 4 of the Biodiversity Act 2002, and criminal court also made a remark that NBA was negligent in performing its duty, Lordship. And the appellant has appealed against the decision passed by the magistrate court in the present Bangalore High Court, Lordship. Now, Your Lordship, if the subject matter is clear, Your Lordship, counsel like to proceed with the issues raised. Much obliged, Your Lordship. Your Lordship, the various issues raised in the present case is with regard to whether criminal court or in convicting Biologist Jeevanti under section 3 of the Biodiversity Act 2002, whether criminal court or in convicting Bangalore Agricultural University under section 4 of the Biodiversity Act 2002, and whether the remark made by magistrate court regarding the negligence of the National Biodiversity Authority is liable to be expunged, Lordship. If the Lordship is clear with the issues, counsel would like to clarify that counsel will be dealing with the first issue and my co-counsel will be dealing with the rest of the issues, Lordship. However,
You don't have anything on the constitutional validity of that?
the Lordship, however, the issues with regard to constitutional validity of the Act is not raised because, Lordship, practically a writ petition and a criminal appeal cannot be combined together, Lordship. Never in the history of India, Lordship, it has happened that a criminal appeal and a writ petition is combined, Lordship. They are governed by two separate courts, Lordship, and in a case if these both things can be entered together, Lordship, that will create a situation of ambiguity and uncertainty, Lordship.
No.
The Lordship, counsel
Take a
is
simple question. In a criminal appeal, a writ petition cannot be enjoined.
Indeed, Your Lordship, they cannot be
But
clubbed
in a writ
together.
petition and criminal appeal can be enjoined in India. So it is a parent material, the laws are. So imagine that it is 226, we are enjoining criminal appeal and all. We are ruling in favor of this. This is a writ jurisdiction under 226, and we have permitted the appellants to raise it, and also we are hearing sitting under 226. We are also hearing appeal, criminal appeal. Imagine that is a ruling made by this court, and please ask.
Much obliged, Your Lordship. Your Lordship, even if we assume that the present petition can be compiled together, Your Lordship, then Your Lordship, this court itself pointed out that the constitutionality issue cannot be dealt because it is in violation of section 31(c) of the Constitution of India 1950, Your
It
Lordship.
can be argued under 21, if it is not under 14 and 19.
Your Lordship, pardon, Your Lordship.
31 bars questioning the constitutional validity only under Article 14 and 19. It can be questioned under Article 21.
Indeed, Your Lordship, it can be questioned. In that case, counsel will argue that the present Act, Section 3 of the Biodiversity Act, is very well constitutional, Your Lordship. However, Your Lordship, if the court is satisfied with this argument, that then, Your Lordship, in that case, Council will argue that Section 3 is not violative or is not unconstitutional, Your Lordship.
Go on to your first issue.
Much obliged, Your Lordship. Your Lordship, the first issue is with regard to whether Section 3 of the Biodiversity Act is in whether criminal court ordered punishing biodiversity under Section 3 of the Biodiversity Act, Your Lordship. Your Lordship, it is humbly submitted that the criminal court did not order convicting biodiversity under Section 3 of the Biodiversity Act, Your Lordship, because, Your Lordship, the criteria which is laid down in Section 3 of the Biodiversity Act is very well satisfied in the present case, Your Lordship. If you may refer to Section 3.2 C2 of the Biodiversity Act 2002, Your Lordship, it is given that if a company is incorporated or registered in India under any law of the continuing force which has any non-Indian participation in the share capital or management, in that case, that company will fall within the definition of person under Section 3.2 of the Biodiversity Act 2002, Your Lordship. Now, Your Lordship, if you refer to para 7 of the Moot proposition, it is clear that in the company Biodiversity Jivanti, Biodiversity Corporation is holding 26% share, Your Lordship. From this, it is crystal clear, Your Lordship, that applicants do come within the ambit of Section 3.2 of the Biodiversity Act. Now, coming back to Section 1 of the Biodiversity Act, Your Lordship, primarily two conditions need to be satisfied, Your Lordship. The first condition is being that permission of National Biodiversity Authority is important, Your Lordship. And the second condition is that the party must have obtained any biological resources occurring in India or knowledge associated for research or for commercial utilization, Your Lordship. Your Lordship, if you may refer to page 2, para 5 of the written submission, Your Lordship, in the last 3 lines, Your Lordship, this is the first case in the country of India, and since the law of India is carrying with the country of India, Council can use this authority, Your Lordship. This is the first case for invoking in which Section 3 of the Biodiversity Act 2002 were invoked, Your Lordship. In that case, Your Lordship, without obtaining necessary permit from the required authority, they have obtained biological resources of the country of India, Your Lordship. So in that case, it was held that a legal presumption that in that case, Your Lordship, it was held that mainly because of the fact that they have not taken approval from the required authority, it can be presumed that their motive was commercial, Your Lordship. You may refer to para 5 of the page number 2 of the written submission, Your Lordship. Last 2 lines, Your Lordship, says to obtain the necessary permit to enter into a protected area and collect insect specimen led to the legal presumption, Your Lordship, that they had commercial motive, Your Lordship. And in the present case, Your Lordship, Biodiversity Jivanti has not taken permission from National Biodiversity Authority, Your Lordship, because Your Lordship, nowhere in the fact it is mentioned that they have taken permission from National Biodiversity Authority, Your Lordship.
Taken permission for what? What act? You need permission. Admitting that you need a permission. Permission for what act?
Permission for incorporating the BTG for obtaining biological resources which is occurring in the country of India, Your Lordship.
Can you please read the section? Let us know where exactly.
Section 3, Your Lordship. Your Lordship, Section 3, it refers that in order to obtain the last 2 lines, obtain any biological resources occurring in India or knowledge associated thereto for research or for commercial utilization.
What is the violation?
Your Lordship, they have not taken permission of National Biodiversity
For what?
for research or for commercial utilization, Your Lordship. Your Lordship, commercial utilization is defined under Section 2F of the Biodiversity Act, and research is also defined under Your Lordship under 2M of the Biodiversity Act, Your Lordship. Council just proved that how it can be said that they have not taken commercial approval, Your Lordship, and they had intention to commercially utilize this project, Your Lordship. Commercial utilization, Your Lordship. Your Lordship,
Please read the definition of commercial utilization.
indeed, Your Lordship. Your Lordship, it reads as commercial utilization means end use of biological resources for commercial utilization. Exception is that, Your Lordship, conventional breeding and traditional practices are not included under the definition of commercial utilization, Your Lordship.
Company is saying they incorporated the BTG under traditional methods.
Indeed, Your Lordship, that was the contention of the company, Your Lordship. But, Your Lordship, in order to counter that contention, Your Lordship, it is contended that since this is a new act, Biological Diversity Act,
You have to give us scientific evidence for that. Please, if you have any scientific evidence.
Yes.
Otherwise, it will be difficult for us to
Your Lordship.
appreciate your argument.
Your Lordship, if you refer to Annexure A of the Moot proposition, Your Lordship, there the commercial...
What is the traditional method and what is the scientific method? You have understanding or not?
Your Lordship, Council...
Otherwise, it will be difficult for us to enlighten on this particular point.
Indeed, Your Lordship, Council do have understanding about this traditional method and scientific method, Your Lordship. Your Lordship, what applicants has done, Your Lordship? Your Lordship, they have used traditional back crossing, Your Lordship. And Your Lordship, if you refer to annexure A of the Moot proposition, their commercial motive, Your Lordship, is clear from the second para, Your Lordship. Stanford Agriculture University, Your Lordship, which was a leading agro-technology provider in the country of Indus, Your Lordship. Their one motive which is clearly given is that to develop product and commercialization, Your Lordship. It is mentioned in the second line.
What is the definition of biotechnology?
Your Lordship, biotechnology.
Legal definition of biotechnology.
Your Lordship, biotechnology is in
Where we get that legal definition in India?
Your Lordship, definition of biotechnology is legally is no, it is not nowhere defined in any act.
Even in 1986 rules?
Your Lordship, in 1986 rule which deals with biosafety rules, Your Lordship.
I don't know.
Your Lordship, council is
You have
not.
to enlighten us.
Your Lordship,
You have
council.
to help us. You are a friend of the court.
Your Lordship, council
Help
is.
us to help you.
Your Lordship, council is not aware of.
1986 rules is there.
1989 rule is there. That
Okay,
is biosafety rules, Your Lordship.
Other rules are there.
Indeed.
Whether any definition is there for genetic engineering or biotechnology.
Your Lordship, council is not aware of the fact
You
that.
should have the BAR Act, you will be having it.
Uh,
Why don't you refer to it? Is there any definition in India for genetic engineering or biotechnology or OCED definition or under CPD? Because we are incorporated CPD through this act.
Indeed, Your Lordship.
What is the definition of biotechnology under CPD?
Your Lordship, it is the contention of the council that the definition per se is not defined in any law.
Let's enlighten us. This court is very ignorant of this definition. Enlighten us. You are very, very enlightened, but we are not enlightened.
Your Lordship, but from the preamble of Convention of Biodiversity, the definition can be assumed, Your Lordship. Because Your Lordship,
Application of scientific and technological methods on biological resources to obtain services and goods for human consumption. That is a definition of third generation biotechnology.
Your Lordship, council apologizes for the limited knowledge of the council.
So, any application of scientific and technology on biological resources necessarily result in commercial utilization per se. You cannot separate it, research and commercial utilization going by the definition of biotechnology.
Your Lordship, in that
Third
case,
generation biotechnology. We are into the third generation of biotechnology. Do you agree with that?
agree, Your Lordship.
What is the first generation type of biotechnology?
Your Lordship, council apologizes.
First generation biotechnology is going by nature without any application of scientific method. That is what traditional method. That is also covered under the Seeds Protection Act and all Farmers Varieties Act. So that is what my brother just wanted to know, whether any scientific involvement is there or it is simply crossbreeding first generation biotechnology. I am making it very, very simple and also technical, highly technical. Whether we are referring to first generation biotechnology or second generation, the chairman will enlighten on this particularly. He is very, very interesting. So you address it. Whether any scientific involvement is there for the application of Section 3.
Your Lordship, there are scientific involvement which is done by the applicants, Your Lordship, because the BT gene which was produced by BioRate G1, Your Lordship, they have inserted BT gene into the sound material which is given in the annexure A of the.
So we are involved. We are dealing with biopatents, isn't it?
Bio?
Patents. This gene is patented, isn't it?
Gene-
As per the
Is the gene inserted by traditional method or
that is why I said
scientific approach?
Your Lordship, gene can be inserted by traditional approach as well as
In the
by
present
scientific
case.
method, Your
In
Lordship.
the present case.
In the present case, Your Lordship, applicant argued that they have inserted gene by way of traditional method, Your Lordship. But Your Lordship, the overall result of insertion is that they violated Section 3 of the Biodiversity Act, Your Lordship. Because Your Lordship, they have not taken approval of National Biodiversity Authority, Your Lordship.
Why should they, when they are doing it in traditional method?
Because Your Lordship, they have obtained biological
The law
resources.
doesn't prohibit that. It is a prohibitive theory, applying the prohibitive theory of law, international law. The law doesn't prohibit for traditional method of the biotechnology.
But Your Lordship, on the other hand, Section 3 very, very clearly points out that if a person which comes within the definition of person given in Section 3 to Your Lordship, if that person is obtaining any biological resources which occurs in the country of Indus, Your Lordship, in that case, they have to take permission of National Biodiversity Authority laws. And Your Lordship, Council already pointed out the recent case, that is the 2008 case, Your Lordship, in which commercial motive is very well clear from the fact that the person that is said has not taken approval of any National Biodiversity.
You weakened your argument by pointing out that it is traditional methods and it is not covered under this Act.
It is not.
And the research started before Act came into existence, as was presented earlier.
Your Lordship, Council thinks that court has misinterpreted what Council has said, Your Lordship. Your Lordship, it was the contention of the appellate that they have used traditional method. Now Council is saying, Your Lordship, and the research was started only for BTG, Your Lordship, that too in 1998, Your Lordship. But Your Lordship, when Biodiversity Act 2002 came, they needed to take permission from National Biodiversity Authority for incorporating BTG into the Act, Your Lordship, which they have not taken, which they failed to take, Your Lordship.
Is that requirement pointed out anywhere here in this document?
Which document, Your Lordship?
The case.
The facts.
Facts.
Indeed, Your Lordship, in the fact, it is very well alleged by the criminal court, Your Lordship, that we have violated Section 3 of the Biodiversity Act. In the paragraph 23 itself, it is mentioned that, Your Lordship, they have violated Section 3 because they have not taken permission from the National Biodiversity Authority, Your Lordship.
The contention is that they have started work prior to the Act.
On BTG, Your Lordship. They have started research on BTG, Your Lordship. And when Biodiversity Act came into existence, then according to Biodiversity Act, Your Lordship, they were needed to take permission from National Biodiversity Authority, which they failed to take, Your Lordship. And this is the only contention of this one. And Your Lordship, even if we assume that they are not covered by Section 3, Your Lordship, then Your Lordship, they can also not claim exception under Section 5 to the Section 3 of the Biodiversity Act, Your Lordship. Because, Your Lordship, they have got claiming exception under Section 5 of the Biodiversity Act, Your Lordship, they have to fulfill two conditions, Your Lordship, which is mentioned in Section 5(3) of the Biological Diversity Act 2002, Your Lordship. The first condition is that they have to conform to policy guidelines issued by the central government in its behalf, Your Lordship. And Your Lordship, it is the contention of the respondents that they have not abided the policy guidelines issued
What
by
is the policy guidelines?
Your
In the
Lordship,
absence of no policy guidelines, why should they follow that?
Your Lordship, there were policy
So
guidelines.
you are asking us to follow a rule which is not in
Indeed not, Your Lordship.
What is the
Council
policy
is not
guidelines?
policy
Tell us what is the policy guidelines which is pertinent to us.
Your Lordship, the policy guidelines which was issued on 8 November 2006, Your Lordship, by central government, that policy council had, for the applicant has not abided by that policy guidelines, Your Lordship.
Tell us what is the policy
Your
guidelines.
Lordship, you may refer to this
Read it.
petition, Your Lordship.
You read it and send it to us. That is
Council have,
then you read and then give it to us.
indeed, Your Lordship. Your Lordship, in the policy guidelines, if you refer to para 2.2, Your Lordship, for para 2.2 of the policy guidelines, there it is mentioned that if collaborators, all collaborators shall abide by the provisions of existing national laws, regulatory mechanisms, and international agreements of treaties, Your Lordship. And it is
What is the
a
legal validity of this guidelines?
Your Lordship, this guidelines is applicable, Your Lordship, under para 2 of this guideline itself says that this guidelines shall come into force, Your Lordship, on date of its publication, Your Lordship.
It has been published?
It is published, Your Lordship,
Where?
in the official gazette, Your Lordship.
When?
And when it will,
When?
on 8 November 2006, Your Lordship.
Are you sure?
Indeed, Your Lordship.
There is a gazette notification for this.
Pardon, Your Lordship.
Where is the gazette notification for this?
This is the gazette notification, Your Lordship.
Is the court supposed to know about a gazette notification?
That's why Council is providing the gazette notification to the court, Your Lordship.
Section 52 evidence and anything else there will?
Then Council will then give some time to the Council. Council will provide the
You
original.
are jumping on presumptions, you know that.
Your Lordship, if some
Presumption
time.
of fact is permitted, presumption of law is not.
Agreed, Your Lordship. Presumption of law is not permitted, Your Lordship.
Because we are getting old.
Your Lordship, it is the contention of the respondent that they have violated many acts like Farmers' Rights Act 2001. They have also violated Food Safety and Standard Act 2006. In addition to this, they have also violated Biosafety Rules 1986. Your Lordship, further,
Are you also addressing the court on violation of section 4 by the university?
Your Lordship, my co-counsel will be dealing with that issue, Your Lordship. Further, Your Lordship, they have also violated many international conventions, like they have violated Convention on Biodiversity, Your Lordship. They have also violated Cartagena Protocol, Your Lordship.
Oh.
Your Lordship, they have violated the basic objective 1 preamble, section 4.
What is Cartesian? What is the objective of Cartesian protocol?
Your Lordship, under Article 1 of the Cartesian Your Lordship, the objective of the Cartesian protocol is to further the objective of conventional biodiversity and primarily talk about the precautionary principle, Your Lordship.
When there is a movement of genetically modified organisms or LMOs.
LMOs, Your Lordship.
Yes. When there is no movement, there is no trade in LMOs or GMOs, Cartesian protocol will not come into picture.
In that case, Your Lordship, Conventional Biodiversity Act will come into picture, Your Lordship.
What is which provision?
Pardon, Your Lordship?
Which article of CBD
Which article of CBD?
will come into picture?
Your Lordship, they have violated many articles of CBD, Your Lordship.
You argue. You argue your case. Don't argue their case.
Your Lordship, under Article 10 of the Convention on Biodiversity, it is
What Article 10 deals with?
Your Lordship, Article 10 deals with the fact that Article 10 says that in national decision making, every country should follow the principle laid down in Cartesian protocol, Your Lordship. Under Article 10 of the Convention of the Council, apologize for the inconvenience first. Under
You are
Article
confused between Cartesian protocol and CBD. Clearly, submit. Take your
Pardon,
time.
Your Lordship, pardon, Your Lordship, for the inconvenience first. Your Lordship, now Council is arguing for conventional biodiversity, Your Lordship. Under Article 10 of the Convention on Biodiversity, it is specifically given that a court in national decision making should take into consideration the objectives of Convention of Biodiversity, Your Lordship. Now, Your Lordship, under many articles of the Convention of Biodiversity, it is specifically mentioned that a party
Give me
cannot.
one article, that's what I want.
Your Lordship,
You say number of articles, give me one article, that's
in the
what
preamble itself, Your Lordship,
Preamble what it says. It doesn't speak about biosafety. It speaks about conservation and preservation of biological resources and also
sustainable
biodiversity.
development and fair and equitable treatment, Your Lordship. There are three objectives this is given in Convention of
But there is no
Biodiversity.
biosafety.
Your Lordship,
CBD doesn't speak about biosafety at all.
Your Lordship, because biosafety already came in 1989, Your Lordship. Because Your Lordship,
No, you are talking about CBD and Cartesian protocol 2000.
Your Lordship. Now Council is talking about Convention on Biodiversity, Your Lordship. Your Lordship, if you refer to Article 8G of the Convention on Biodiversity, Your Lordship.
Yes, with traditional knowledge.
Your
8J.
Lordship, 8G refers that any country should preserve and respect and maintain knowledge of indigenous and local community. And that is the sole argument of the Your Lordship Council needs some more regulation. Much obliged, Your Lordship. Your Lordship, this is the sole argument of the respondent that the appellate has used the traditional knowledge which is possessed by the farmers of the country of Indus, Your Lordship, and they have commercially utilized that traditional knowledge in order to benefit themselves, Your Lordship.
Are you a benefit claimer?
Under section 2 of the Biodiversity Act 2002, my time came in with the definition of benefit claimer, Your Lordship.
Oh, you are only cultivating certain 5 varieties of eggplant. How can you become a
Because
benefit claimer?
Your Lordship, the definition begins as benefit claimer means the conserver of biological resources, Your Lordship. My client is the conserver of biological
So
resources.
your fact says you are a cultivator, that's all. What is the meaning of a cultivator?
Who
Dictionary
cultivates?
meaning.
Who cultivates? One who cultivates is a cultivator.
He is not a cultivator.
My client is a cultivator because Your Lordship,
No, whether a cultivator will fit into the definition of benefit claimer. I am asking a very pertinent question. Whether a cultivator will squarely fit into the definition of benefit claimer.
Indeed, Your Lordship.
How? Where
Because-
is the authority?
Your Lordship, it is the section 2A itself is the authority because it mentions that conservers of biological resources, Your Lordship, and conserver include cultivators, Your Lordship.
Where is the authority? Give me the authority.
Section 2A itself is the authority, Your Lordship.
That is your interpretation. For that interpretation,
Your Lordship, there are no.
whether it is regular interpretation or narrow interpretation, or it is a textual interpretation or contextual interpretation.
Your Lordship, this is a harmonious interpretation made.
Harmonious between which two parts?
Your Lordship, between section 2A of benefit claimer and section 61 of the Biodiversity Act 2000. Your Lordship, says not many cases are available in the country of India.
So when you
So this court can develop new principle, Your Lordship.
for that we need authority. That's all I am asking.
Your Lordship,
We simply out of the blue we cannot give like Moses. We cannot give you a law. We need something.
Indeed, Your Lordship, agreed, Your Lordship.
Yes, we have to feed us with it. That's what I am. Give us authority. That benefit claimers also include cultivators.
Your Lordship,
Somewhere, some from comparative research. Somewhere, some foreign, French, Spanish, Brazil, megadiverse, 14 megadiverse countries are there. Their practice
that
of
is mentioned in
anything.
the fact sheet, Your Lordship.
Your research is not up to the standard.
Your Lordship, Council, please apologize for the same, Your Lordship. So Your Lordship, it is the contention of the Council that it has violated many conventions like Convention on Biodiversity and other conventions, and they have also violated many acts, many national laws, Your Lordship, hence they have not abided by the
Have you
following.
addressed the first issue?
Pardon, Your Lordship?
Have we completed the first issue?
Indeed, Your Lordship, just give 1 minute, Council will sum up the issue, Your Lordship.
Not necessary. Okay. You have submitted the issue. Yes.
With this, Council rests so that the co-council proceeds with the next issue.
If it pleases the Honourable Court, may the Council proceed to the next issue? Much obliged, Your Lordship. Your Lordship, the Council for responding would like to contend that Criminal Code of Bangalore did not err in directing NB to calculate loss and recover it as benefit sharing. Your Lordship, BD Act kindly refer to the preamble, is drafted to achieve the objective of CBD 1992.
Can you repeat your opening statement? Remarks?
Biodiversity Act, if you refer to preamble, it is drafted to achieve objective of Convention on Biodiversity 1992. And Your Lordships, one among the objectives is fair and equitable benefit sharing, Your Lordship. Lordship, further, what is benefit sharing? I will just give you in brief. It is a biodiplomacy effort that awards contracts between bioprospectors and source countries so that with the intention that royalties between them are shared amicably. And Your Lordship,
For conservation of biological diversity.
Indeed, Your Lordship.
So you have to finish with for conservation of biological diversity. Benefit sharing is for conservation of biological diversity. Is it so or not?
Indeed, Your Lordship. And Your Lordship, it also assures the developing countries that all the environment safeguards would be abided by. Your Lordships, under Biodiversity Act 2002, Section 18(1), Section 2G, 19, 20, 21, 53, Your Lordships, it says that what is benefit sharing? Benefit sharing is what is determined by National Biodiversity Authority. It has power and duty to determine benefit sharing. And Your Lordship, under Section 18(1), it is the duty of NB to regulate activities under Section 3, 4 and 6. And Your Lordship, under Section 53 of the same Act, the order made by NB in this behalf is decree executable. So Your Lordship, the contention of the respondents is that BGL violated principle of benefit sharing, which is enshrined in several international principles and treaties, Your Lordship. Your Lordship, firstly, it did not take pride.
BJL violated or NBA violated? You have been quoting the power duties of the NBA. It is a supervising authority. It is a duty of the NBA to get the benefit sharing. Why are you blaming the person? Enforcement authority has squarely failed.
Your Lordship, the sections which I have read.
I think you are barking at the wrong tree.
Indeed not, Your Lordships. Your Lordships.
You have quoted freely various sections of the National Biological Diversity Authority. It is the duty of the NBA. NBA has to ensure that there is an access and also these things. And why are you blaming the company?
Indeed not, Your Lordship. The sections which I have referred is just to show that NB has power.
Yes, that power has not been exercised. That power has not been exercised by the NBA. So you blame the NBA. Why are you blaming the company?
Indeed, Your Lordship, in my next issue, I will be dealing with that.
You address that and then we will go to this.
Much obliged, Your Lordship. Your Lordship, the issue is that the respondents humbly submit that criminal code did not err in criticizing the role of NBA and the same is not liable to be expunged, Your Lordship. Your Lordship, first of all, if germplasm is used in any company, by any company in India for their development or research purposes, etc.
Why I ask this question is refer to para 23.
Indeed, Your Lordship.
Then why are you wasting our time? The district court has clearly said to calculate loss cost and recover amount as compensation and distribute it to farmers of benefit sharing.
Yes, Your Lordship. The contention of the council is saying, Your Lordship, that NBA has power to determine benefit sharing, and Your Lordship, secondly, that
So you are appealing against this particular. You are defending their appeal. They have not come before us for this particular thing. This is not an issue at all.
Your Lordship, this is an issue.
There are three issues, isn't it? One is violation of 3,
Yes, indeed, Your Lordship.
4,
Yes, Your Lordship.
and 4 coupled with 5th. If you have an exception under 5th, 3 and 4 will not come in.
No.
And also expulsion of these remarks and also
Your
constitutional validity of the act.
Your Lordship, the appellant, one of the appellant is also NBA, which has appealed before High Court of Bangalore to expunge the remarks.
You address that. You address that.
Yes, Your Lordship. Your Lordship,
Suddenly you are moving to benefit sharing. It is only negligent, with reference to negligent, I believe. Death of the farmers, etc., etc. Not with reference to benefit sharing, definitely.
yes, Your Lordship.
Yes.
Benefit sharing.
Why are you diverting our attention?
Council apologizes for the same, Your Lordship. Your Lordship, the contention of the council is that if the germ plasm used by any company in India, for their development or research purposes, etc., the same contains any Indian germ plasm, then the particular matter will come within the ambit of NB.
What is germ plasm?
Germ plasm is the genetic collection of
Is there any difference between biological resources and genetic resources?
Your Lordship, the definition is given under section.
What is your understanding? Just tell us. You need not give an acceptable legal definition. What is your understanding of genetic resources and biological resources?
Your Lordship, biological resources refers to genetic resources is a subset of biological resources, Your Lordship, and Your Lordship, germ plasm is also in case of.
We have science and law. Application of law to science. If you are going to argue without background of science,
Your
it is
Lordship,
difficult for us to appreciate your argument.
Your Lordship, the
You
argument.
should have come prepared with scientific background also, because nation needs it.
Your
Our
Lordship,
country needs it.
Your Lordship, section 2 of the Biodiversity Act, Your Lordship, gives definition of biological resources, Your Lordship, and it states that it means plants, animals, microorganisms, or parts thereof. So, Your Lordship, biological resources is a larger set, and genetic resources of germ plasm is a subset of it, Your Lordship, because germ plasm is genetic collection of the resources, Your Lordship. In case of plants, it is seed, Your Lordship, but the plant itself can come within the ambit of biological resources, Your Lordship. So, Your Lordship, this particular matter, if Indian company is using...
Seed is a biological resource or genetic resource? The seed as such.
Your Lordship, it is a biological resource as well and a genetic resource as well.
A gene, whether it's a gene is a biological resource or a genetic resource. A gene in the nucleus.
Your Lordship,
Because we are dealing with genetic engineering.
Your Lordship, it is also a biological resource. Because as I just mentioned, Your Lordship, biological resource is the larger...
I am a human being, this is brain, this is heart. So I am also, heart is also a human being. That's what your argument is. Be specific.
Your Lordship, section 2C only, it mentions that means plants, biological resources means plants...
No, I never referred to those sections. I am asking your common understanding whether seed is a biological resource or
Yes,
a
Your
genetic.
Lordship, it is a biological resource.
Then gene,
Gene is also a biological resource.
then what is genetic resource?
Your Lordship, it comprises of genes only.
Yes, that's all.
Is genetic resource defined anywhere?
So we are just testing whether how broad your research is. Nothing. You are heading in the right direction. Go ahead. Go ahead. You are heading in the right direction. You just wanted to whether you are broad based or not.
Much obliged, Your Lordship. Your Lordship, NB is an autonomous body and it completely neglected its duty and failed to inquire in the present matter, Your Lordship. Your Lordship, rather DBT, whose stated objective is to promote GM crops, the genetically modified crops, Your Lordship, and whose powers are restricted to framing of guidelines for good lab practices, had given approval for commercialization of the BT brinjal, Your Lordship, whereas GEAC is the proper authority to give commercialization approval for the BT brinjal, Your Lordship. Your Lordship, DBT comes under Ministry of Environment and Science, Your Lordship, whereas GEAC comes under Ministry of Environment and Forest, Your Lordship. DBT comes under Ministry of Science and Technology, and GEAC comes under Ministry of Environment and Forest, Your Lordship. Your Lordship, this is also to Council would like to...
That is the difficulty. That is the problem. So you have to come with the solution. Yes, we are expecting solution from you.
Your Lordship,
You are saying this is different, and the patient is the biological diversity. Come with some concrete proposal. You are interested in protection of Indian biodiversity.
Indeed, Your Lordship.
Come with some solutions.
Your Lordship, first of all, the contention in this issue of the council is that the particular remark made against NB should not be expunged, Your Lordship, because under Your Lordship,
Forget about that. Move on to the next issue.
Before you go, you should give your view on the contention of the appellant that the problem of this genetically modified crop came under the purview of GAC and they are not responsible for it. If they were not responsible for it, if you accept that argument, then you have to explain this.
Your Lordship,
structure
under the Your Lordship, I would like to submit that under the guidelines of guidelines for confined agricultural trials, Your Lordship, page 10, rule 7 of guidelines for confined trials, it says that onus is on the party to provide for data and comply with procedures. It's on the party, Your Lordship. And Your Lordship, it can be seen that from the paragraph 17 that DBT has given all the approvals, Your Lordship. Your Lordship, no regulatory procedures were followed, Your Lordship, as given in Rule 9 and 7 of the biosafety rules, that unless special permission of GEAC is granted, it is prohibited unintentional and deliberate release of GMO for experimental purpose, and GEAC must approve of import, export, transport, manufacture any hazardous.
As I understand the facts, GAC approval exists.
Indeed not, Your Lordship. Your Lordship, biotechnology is a cross-cutting inter-ministerial activity since several ministries conduct activities in biotechnological field. And Your Lordship, because several ministries...
Irrespective of all of that, GAC, as you stated, comes under the Ministry of Environment and Forest. So any clearances from GAC goes to that ministry. It doesn't come to Department of Agriculture.
Your Lordship, because GEAC has not given approval in the present case, Your Lordship. Your Lordship, the contention of the council is that the GEAC in the present case has not given approval. Rather, the Department of Biotechnology has given approval, Your Lordship. Therefore, GEAC must be, GEAC should have given approval. I mean, the council...
Must be presumed. Should be presumed that GEAC given consent or, approval or not.
No, Your Lordship. GEAC has not given approval, Your Lordship. And the council for appellants, Your Lordship, the appellants must have moved the application to GEAC for the approval of...
Which appellant? 1, 2, 3. Which one of them? We have 3 appellants. Which one of them should...
BJL and
appellant number 1 and 2.
Yes, Your Lordship.
Should have moved to the GEAC to get the approval.
Yes, Your Lordship. Your Lordship, because under confined guidelines for confined field trials, it is...
So, if they have failed to get GEAC approval, under which section of Biological Diversity Act we should punish them?
GEAC comes under what?
GEAC comes under the Ministry of Environment and Forest.
So, this para 13 in the fact says that they have taken approval from the Department of Biotechnology. What is the locus standi of the Department of Biotechnology? Actually, you should have actually taken this case against Department of Biotechnology and not against the NBA.
Your Lordship, because it is an appeal case and we must stick to the appeals present by the appellants, Your Lordship. The reply to the appeal, the reply should be confined to the issues raised by the appellants, Your Lordship. And because they have not raised this issue, so thereby I am not replying to them.
If you look at the facts, then we are actually beating the wrong horse. Because the mistake is on the part of the Department of Biotechnology, but we are blaming the NBA for that mistake. That's it. As far as the company is concerned, they say they have taken the approval.
Your Lordship, Department of Biotechnology is also under fault as well as NBA is also under fault because, Your Lordship, several sections of the BD Act say that NBA has the duty to regulate all activities including approval in the subject that is related to access to biological resource and to facilitate, enable, conservation action such that fair and equitable benefit sharing can be achieved. Section 18 of the Biodiversity Act states that NBA has duty to comply with all the social actions.
Good.
So, Your Lordship, in case of
Are
daughters,
you not confident about your argument?
yes, Your Lordship.
You are finishing your statement in a melodious manner. It is not emphatic. You are not confident of what you are arguing.
No, Your Lordship.
There is no personal conviction.
Council is confident, Your Lordship. Your Lordship,
Have you addressed us on section 4 binding?
Yes.
yes, Your Lordship.
Please address us.
Your Lordship, the issue is that criminal code did not err in making Sao liable under section 4 of the BD Act 2002 and it does not come under exception 5. Your Lordship, on the plain reading of section 4 of the Act, I would request Your Lordship to go through section 4 of the Act. Approval of NDA must be taken when there is transfer of any research relating to any biological resource occurring in or obtained from India to corporate registered in India having non-Indian participation. Your Lordship, according to Annexure A of the Moot proposition, Sao materials, that is eggplant germ plasm, developed, owned, licensed, is made from indigenous resources, Your Lordship. So, Your Lordship, therefore it requires permission from NDA, Your Lordship. And Your Lordship, the contention of the appellant is that it is a collaborative research project and it comes within the exception of 5, Your Lordship. To counter this point, Your Lordship, section 5 of the BD Act, as per the interpretation given on the NBA web page, Your Lordship, it must include, Your Lordship, 2 research institutions. One must be from India and 1 research institution must be from foreign country, Your Lordship. Your Lordship, also under section 5(3)(b), Your Lordship, the guidelines are issued for collaborative research project, Your Lordship, and Your Lordship, reading the section 5 and international guidelines for collaborative project, Your Lordship, harmoniously, it can be stated the interpretation can be this, Your Lordship, that one research institution must be from country of Indus and 1 research institution must be from foreign country, Your Lordship. Secondly, Your Lordship, that it must be government sponsored, Your Lordship, both the institutions, because Your Lordship, it states that exchange of biological resources or information relating thereto between institutions, including government-sponsored institutions of India and such institutions. Such institution means that government-sponsored institutions.
Is definition an exhaustive definition or illustrative definition?
Your Lordship, it is an exhaustive definition.
Why?
That means that
The word is used including. How can it be an exhaustive definition? And when something when there is a usage of like means includes, then it is very sentiment.
Your Lordship, it only includes government-sponsored institutions of India and
The plain reading doesn't sound that way.
Your Lordship, because after there
between institutions, then they say including. It is an illustration. That's all.
including and comma, Your Lordship.
Yes, including. That's an illustration.
Such institutions doesn't mean
Yeah.
all other government institutions.
Yes, that's
Such
it.
institutions could mean all other biotechnology institutions.
Institutions.
But Your
It is only
Lordship,
illustrative wordings, including.
Your Lordship, the Council also has taken reference from the NDA webpage, where the NDA webpage, Your Lordship. Your Lordship, where the interpretation of this section is given like this only, that it includes institutions, it must include institution of country of India and institution of country of a foreign country, and both the countries must be government sponsored.
Are we bound by the instructions put on NDA webpage? Is this code bound to go by that webpage?
Indeed, Your Lordship, but it is for the reference of the contention the Council is making, Your Lordship.
We need your help to interpret this law.
See, you have approached the lower court.
Your Lordship,
You are simply evading your responsibility. You are approached the lower court, and it is based on your plaint. Your charge sheet. Entire case is built upon. You are now coming and saying whatever they said, we are going to refute that.
indeed, Your not your lordship. If your
This
lordship...
is your stand before us.
No, your lordship.
Shying away from your responsibility of proving certain violation of or what is the misdeeds or whatever it is. They have argued only this much. I am going to answer only this much because the entire proceeding, appeal, whatever it is, based on your position before the trial court. What is your position before the trial court? Tell us. Reiterate.
Your lordship, first of all, I would like to give my opinion on the interpretation of section 5, your lordship.
We'll go that later. What is your position in the trial court?
Factual.
Factual. Otherwise, we can't proceed because they are the aggrieved person there before us. You cannot say, so they are coming in, okay, we will stop. Whatever they have, we will answer, we will stop. No, you have initiated. You have to set the wheels on motion. You have to tell us what is your position before us.
The contention is that the appellant have violated section 3 and section 4 of the Biological Diversity Act by not
Tell us
taking permission from NDA, your lordships. By not taking permission from NDA, lordships, when after 2005 when the agreement was entered into the collaborative research project.
That has been addressed by your co-agent. What is your addressing? NPA?
Your lordships, section 3 and 4 are...
I'll make it very specific. Forget about all these things. What is according to you the role of NPA in this case? Whether NPA failed miserably,
Yes,
failed,
indeed, your
it's
lordships,
just their failed, that's all.
The contention of the council is that NDA failed in
How?
inquiring into the
In what?
Your
In
lordship,
what?
because...
Help us. In what manner the NPA has failed? Let the whole world come to know the functioning of NPA.
Your lordship, firstly that in the Biodiversity Act itself, the procedures and the duty of the ND has been given and it has not complied with the duties.
But which duty? Be specific. You are before us in appeal and also under 226. Be specific. Don't waste our time.
Section 18, your lordship.
Section 18, which portion? NPA 304A. Now you are jumping to some other conclusion.
Your lordship, but because...
Your contention before the trial court was they are negligent of 304A. Now you are deviating from that 18A, they have not got. What is this?
Your lordship...
You are deviating from the main issue.
No, your lordship, indeed not your lordship.
In the lower court, what is your contention?
Your lordship, the contention was that ND neglected its duty and because of that, deaths have occurred, your lordship.
Clearly the clarification between 304A. What is your answer to that? You are not argued on that point.
Your lordship, because the finding of the lower court says that there is no evidence that ND, because of ND...
But now you have to counter that there is evidence.
No, your lordships.
That is what the appeal is all about.
Your lordship, death might not have...
You are not aggrieved by they have come before us for the appeal because they are aggrieved. You must say, no, the lower court has done correctly. Therefore, there is no, it cannot be, it is not tenable in law.
Your lordships, we are not contending that deaths have occurred because of NDA, but your lordships, instead, there is also a point that it has violated...
So do you want to say anything about the constitutional validity of the act? Constitutional validity because they raised it. Because you said, you restricted yourself. Whatever they said, I will counter and keep quiet. Now they have raised the constitutional validity of BD Act. What is your answer to that?
Your lordships, this was the issue raised by my co-counsel and I would like to seek assistance from my co-counsel.
Why don't you? As a team, you are there.
Your lordships, the BD Act is constitutional.
Because I don't find anything in your memorial regarding the constitutional validity of the act.
Because as already said by my co-counsel, your lordships, it is impossible or we haven't found any authority as such, your lordships, in the Indus country that a criminal appeal and a writ petition is combined and heard before the same court.
But a writ petition and criminal court appeal can be combined. You didn't find any authority for that?
Your lordships, even the writ petition argument cannot be included as an argument in criminal appeal petition, your lordships.
With a comprehensive power given to the High Court and the Supreme Court,
226,
you
227.
come with ineffective arguments as to that. If the court says it is taking jurisdiction, how can you say the court did not have jurisdiction to hear? And you have come unprepared to answer that question.
No, your lordships,
If you
the
are
court...
prepared, then address that issue.
Your answer is purely technical, which is we are finding it difficult to swallow that pill.
Your Lordship, the only...
Because you are not arguing the case on merit. Because you are on appeal, on merit, on legal points you should appeal, not on technical grounds.
Your Lordship...
That means you don't have any legal point at all to argue.
Indeed not, Your Lordship. The sole argument regarding this, the sole contention of
At
the
least tell us there is a
Council-
presumption in constitutional validity of this Article 31C, something you have to say, isn't it?
Indeed, Your Lordship.
Territoriality, constitutional validity of the presumption in favor of the constitutional validity of the BD Act, policy cannot be questioned, something.
Indeed, Your Lordship. As Your Lordship has rightly pointed out that under Section 31C, the biological diversity cannot
Article
be...
31C, not Section
Article 31C of the Constitution of India, Your Lordship. Apologies. The BD Act cannot be challenged, Your Lordship. And Your Lordship, the sole contention of the...
But in Minerva Bill's case, the constitutional validity of 31C is questioned.
And they are before the court when they are convicted. So their
But
liberty
Your
is at
Lordship,
stake.
the contention...
Their liberty is at stake. When a person's liberty is at stake, how can this courts be moved?
Article 21.
Your Lordship...
Constitutional validity of 31C is being questioned in Keshawardabadi case as well as in Minerva Bill's case. What is the position?
But Your Lordship, the contention of the Council is
Because
that...
simply I gave you the cue, you are taking it. I led you to a trap.
Your Lordship...
Are we supposed to limit ourselves to the contention of the council, or can we go beyond it?
Definitely, Your Lordship, we can go beyond it. Your Lordship, but the contention is that the High Court do have jurisdiction under 226, but they must file separate petition for it, Your Lordship. Because it is a criminal bench, Your Lordship.
It is a separate petition, there is a writ petition, and this court calls for...
See, under 226, this court sits in dual capacity. One has a court of law and court of equity. When it sits under court of equity, it has a wider power to call for any records, anything. So using under whatever it is in court of authority, court of law also, we can club anything because we enjoy 227 also. 226 and 227. This has been clearly stated in the facts and clarifications.
Your Lordships, in the case of Jagat Bahadur versus State of Madhya Pradesh, a court of appeal is a court of error and its jurisdiction being co-extensive with that of the trial court. It would be wrong for it to do something which was not within the competence of the trial court.
This is what precisely I was pointing to you. You are helping me. You have been raised 304 there in the trial court and you are raising something here. It's self-defeating.
Your Lordships, we also raised that NBA failed to comply with the duties given in Section 18, Your Lordships, of the BD
Here
Act.
it is said in the facts. Or in the clarification.
Your Lordships, we are contending it, Your Lordships, and because Your Lordships, the failure
Okay, fine. Be fair, honest counsel.
Your Lordships,
Where is it is given in the fact sheet or in the clarification?
Your Lordships, it can be the last 23rd, Your Lordships. Your Lordships, because NB rule has been criticized and we
It is not criticism. The lower court gives a direction, that's all. It is not criticism. It's a direction is given by the lower court.
Your
Or
Lordships, we had
APS.
petition because under Section 18, NPA was to take action.
In fact, they could have taken cue from the lower court and exceeded its jurisdiction.
Your Lordships,
They exceeded the jurisdiction. They cannot direct NBA to calculate amount and give it to them. They can only punish. If they want, they can give compensation. That's all the lower court under criminal procedure code. They can award compensation for the victims. They cannot calculate indulge in the APS.
but Your Lordships, it has just given direction to the NBA to calculate loss.
That is what they are standing before us. That the lower court has erred in law, giving direction to NBA. They want it to be corrected. What is your position for them?
Your Lordships, specific law prevail over general law, Your Lordships. Your Lordship, BD Act under Section 21 gives NBA the power to determine benefit sharing, Your Lordships.
We are talking about criminal procedure code.
Your Lordships. Your Lordships, and that
Because you said it is
also-
only a criminal appeal, only criminal law, criminal evidence should be followed. That's what I am asking you.
Can you differentiate between benefit sharing and compensation? Section 21 speaks
Who is
of
the
benefit
victim here?
sharing.
Who is the victim? Victim has to be compensated, victimology.
Your Lordship, under section
Development
21
of compensatory jurisprudence under Indian criminal jurisprudence.
Your Lordship, under section 21, it states that benefit sharing must be calculated by ND and it must be given to the benefit claimers, Your Lordship, which is given under section 2A of the Biodiversity Act, the benefit claimers definition.
Our question is very simple. Whether a trial court, which is a slave to the Criminal Procedure Code and IPC, and also not IPC, BD Act and Criminal Procedure Code, can it award? Can it calculate ABS? Give a direction to the National Biodiversity Authority to calculate that is the benefit sharing. That is what is.
Read section 55.
You have not read the act properly.
Penalties, Your Lordship. Right.
Whatever so contravenes or attempts to contravene the abets the contravention of provision 3 and 4, 5 years.
Yes, Your Lordship.
Then
The second part.
second part.
Whoever contravenes or attempts to contravene or abets the contravention of the provisions of section 7 or any order made under subsection 2 of section 24 shall be punishable with imprisonment for a term which may extend to 3 years or with fine which may extend to 5 lakh rupees or
And second part, that's more important.
second part. I just read second part.
And where the damage caused exceeds 10 lakh rupees, such fine may commensurate with damage caused or with both. So, who is supposed to give the damages, the court or the agency?
No, Your Lordship. The damages must be paid by the BJL, Your
But
Lordship.
who has to direct it? The provision says,
NBA, Your Lordship.
then the power is with the magistrate. He should. How can he direct somebody to pay a compensation? That is why I asked you what is the difference between benefit sharing and what is the difference between compensation.
And there are also damages or polluter pays principle under sustainable development concept.
Your Lordship, the polluter pay principle says that.
Forget about it. Forget about it. So I know you will. I am leading to another trap. So whether it is a compensation or rightly asked by my brother judge
Benefit
Is
sharing.
it benefit sharing
or compensation.
Benefit sharing. Your
If it
Lordship.
is benefit sharing, did the magistrate have the power to do so?
Under which provisions of Criminal Procedure Code? So they are agreed by that. That is why they are standing before us. You can refer to section 7 also. 7 also Biodiversity Act. No person who is citizen or India body corporate shall obtain any biological resource for commercial play or whatever it is. Don't restrict your argument only to 3, 4, 5. You can also refer to 7. You can go to your prayer. Thank you.
Your Lordship, wherefore it is
You are given
prayed,
equal time, extra time. Fine.
wherefore it is prayed in the light of issues raised, argument advanced, and authority cited, may the Honorable Court be pleased to dismiss the appeal from the order of criminal court, uphold the conviction of BJL for violating section 3 of the BD Act, uphold the conviction of SAW for violating section 4 of the BD Act, declare that the remark made against NBA was correct and necessary part of the judgment, Your Lordship. Direct NBA to suspend action on all applications by any of the agencies involved in biopiracy seeking access to any biological resources of India. Uphold the direction given by criminal court to NBA to calculate the loss, cost and recover the amount as compensation, and pass any other order, direction or relief that it may deem fit in the best interest of justice.
How can we pass any other order if you are not sitting under writ jurisdiction, whereas your co-counsel said it is not coextensive? Appellate jurisdiction and writ jurisdiction cannot be in the practice of interest. Your prayer contradicts your position.
Inherent power of the
Where we get the inherent power? We are sitting in appellate jurisdiction.
Lordship, CRPC, Your Lordship, 480 to the inherent power of the criminal code, Your Lordship. To meet the of the height of the Lordship.
But nobody is in front of the under 480.
Yes.
Clearly stated they have come under 374.
Yes.
Lordships, under 482, the High
But
Court.
nobody is before the court in the 482. If you have made a mistake in the prayer, just withdraw it.
Your Lordship, the counsel for appellants are under 482
They never said. They never said. We didn't. They never said.
374 too.
Yes.
to expunge the remark of made against LV, Your Lordships.
They never contended on these issues.
And even if it is under 482, at what point? Here there is a judgment that is there, somebody is aggrieved by a judgment. Can a judgment be challenged under 482? Can a judgment be challenged under 482?
Your Lordships, it is inherent power.
Inherent power I agree. But there is you are aggrieved by a judgment. Can a judgment be challenged under 482? What is 482?
Your Lordships, it is inherent power of the court for meeting
To
the end of
interfere at any stage of a trial. Not after the court has given a judgment, the matter is not anymore with the court. If you make a mistake, just withdraw the case.
Much obliged, Your Lordship. So, Your Lordship, the prayer of the counsel rests.
Thank you.